address you last, and then I will do the remaining instructions before deliberations begin. You have heard the evidence. The court and the jury have separate functions. You decide the disputed facts, and the court provides the instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change the law, nor to apply your own conception of what you think the law should be. The person who claims that certain facts exist must prove them by a preponderance of the evidence. This obligation is known as the burden of proof. The burden of proof is on the plaintiff, Martin A. Reese, to prove the facts necessary for his case by a preponderance of the evidence. Later, the court will outline and explain the factual issues. Preponderance of the evidence is the greater weight of the evidence, that is, evidence that you believe because it outweighs in your mind the evidence opposed to it. A preponderance means evidence that is more probable, more persuasive, or of greater probative value. You must weigh the quality of the evidence. Quality may or may not be identical with quantity. In determining whether an issue has been proved by a preponderance of the evidence, you should therefore consider all of the evidence regardless of who produced it. If the weight of the evidence is equally balanced, the party having the burden of proof has not established such issue by a preponderance of the evidence. Evidence is all the testimony received from the witnesses, the exhibits admitted during the trial, and any facts the parties have stipulated to, and any facts which the court requires you to accept as true. Evidence may be direct or circumstantial or both. You must decide from all the direct and circumstantial evidence taken together whether the party who has the burden of proof has met that burden. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he or she testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of people. To infer or to make an inference is to reach a reasonable conclusion of fact which you may but are not required to make from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. You may infer a fact only from other facts or circumstances that may have been proved by the greater weight of the evidence. But you may not make inferences from a speculative or remote basis that has not been established by the greater weight of the evidence. The evidence does not include the opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. In the next two paragraphs, I address objections, or there weren't any objections, so those two paragraphs will not apply. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To determine the greater weight of the evidence, you must consider the credibility of the witnesses. You may use the tests of truthfulness which you use in your daily lives. These tests may include, but are not limited to, the appearance of each witness upon the stand, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which the witness testified, the witness's memory, frankness or lack of it, interest and bias, if any, together with all the facts and circumstances surrounding the testimony. By using these tests, you may assign to each witness's testimony such weight as you think proper. You are not required to believe the testimony of any witness simply because he was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to decide what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. If statements in a deposition differ from any testimony given by the same witness in the courtroom, you may consider these statements to test the credibility of such witnesses. Generally, a witness may not express an opinion. However, one who follows a profession may express his opinion because of his education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you arrive at a just verdict. As with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the expert. In deciding its weight, you may take into account you may take into consideration his skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and deciding the weight to be given to the testimony. The Workers' Compensation Law of Ohio provides that employees who were injured in the course and scope of and arising out of their employment are entitled to participate in the Workers' Compensation Fund. The plaintiff, Martin A. Reese, claims that he is entitled to participate in the Workers' Compensation Fund because of 1, other specified depressive order, recurrent brief depression, and 2, panic disorder. The defendant, R.W. Sidley Incorporated, denies that the plaintiff is entitled to participate in the Workers' Compensation Fund for 1, other specified depressive disorder, recurrent brief depression, or 2, panic disorder. Before you can find that the plaintiff is entitled to participate in the Workers' Compensation Fund, you must find by the greater weight of the evidence all of the following elements. 1, the plaintiff was an employee of the defendant employer on January 24, 2019. That fact has been stipulated to by the parties. 2, the plaintiff suffered the following physical injuries: concussion with loss of consciousness of unspecified duration, left shoulder contusion, and post-concussive syndrome. That fact has been stipulated to by the parties. 3, the plaintiff's physical injuries arose out of and in the course of his employment with the defendant employer. That fact has been stipulated to by the parties. 4, the plaintiff suffers from a psychological condition. And 5, the psychological condition the plaintiff suffers from was proximately caused by the plaintiff's physical injuries. Proximate cause is an act or failure to act that in the natural and continuous sequence directly produced the injury and without which the injury would not have occurred. The issue you must decide is whether Martin A. Reese is entitled to participate in the Workers' Compensation Fund. If you find that Martin A. Reese is entitled to participate, you will not consider any amount of compensation. If you find that Martin A. Reese has proved by the greater weight of the evidence all the elements of his case, then your verdict must be that he is entitled to participate in the Workers' Compensation Fund. If you find that Martin A. Reese has failed to prove by the greater weight of the evidence any element of his case, or if you find the evidence is evenly balanced on any element, then your verdict must be that he is not entitled to participate in the Workers' Compensation Fund. All right, counsel will now present their closing arguments. Remember, closing arguments are designed to assist you. They are not evidence. Ms. Krause?
First of all, I want to thank you for the time and attention that you gave this matter over the past day and a half. I also want to thank Ms. Summers for her professionalism throughout this trial. It's a pleasure to try a case with another lawyer who is professional, and I certainly think it makes the process much more streamlined and it gets us through this process much quicker. Throughout the trial, you've actually heard Ms. Summers say a number of times that Mr. Reese sustained a very serious injury and that her client, R.W. Sidley, is not disputing that fact. We heard about the injury he sustained in January of 2019. We heard about the 50-pound piece of metal that struck him in the head and the neck and in the shoulder. We heard about the injuries, the concussion, the rotator cuff tear, the problems from C3 to C7 that ultimately required a fusion surgery in the neck. We heard about the fact that he had to have therapy, including speech therapy, vestibular therapy, cognitive therapy. We heard about the fact that he treated at a concussion clinic with Dr. Mary Vargo. And you're actually going to have the opportunity to have Dr. Vargo's records, some of her records early on from when she saw him and the problems that he was experiencing: nausea, vomiting, light sensitivity, headaches, blurred vision, difficulty sleeping, cognitive issues. These are all detailed in several of her notes, the first being May 14th of 2019. At that time, Dr. Vargo was concerned about some of the psychological symptoms that Mr. Reese was reporting to her. So on August 5th of 2019, Dr. Vargo thought it would be wise for Mr. Reese to see a psychologist. He saw Dr. Kip Smith at Metro. He saw Dr. Smith on just one occasion, and we heard a little bit about Dr. Smith's evaluation in the depositions of Dr. Yingling and Dr. Murphy. Although Dr. Smith didn't make any sort of a diagnosis, Dr. Smith did talk about the symptoms that Mr. Reese was experiencing, and at the conclusion of that assessment, Dr. Smith felt that Mr. Reese could benefit from participating in psychological counseling. So against this backdrop, serious injury, surgery, ongoing problems, ongoing memory issues, is it surprising then that Mr. Reese would develop psychological problems? You've heard from two psychologists in this case, both of whom conducted very similar interviews. They interviewed Mr. Reese, asked him questions about his childhood, asked him questions about his work history, asked him questions about legal history, asked him about his mental health symptoms. They gave him tests, two different tests. Dr. Yingling administered the MMPI, and Dr. Murphy administered the Milan test. And as Dr. Murphy indicated, one's a Mercedes-Benz and one's a BMW. So both of the tests are good tests. It's just that psychologists have preferences with regard to which tests they administered. In those tests, Mr. Reese identified clinically significant signs of depression and anxiety, which was consistent with what he reported to Dr. Yingling and to Dr. Murphy throughout the evaluation. So the question is, why do they disagree? Why do they reach different conclusions? If they reviewed the same records and conducted essentially the same evaluation and administered very similar tests, why is their conclusion so different? And I would submit to you that perhaps it's the perspective that each of the doctors approached the evaluation. Dr. Yingling spends 70% of his time treating patients with psychological issues. Dr. Yingling approached his evaluation from the standpoint of, does Mr. Reese have a problem and can it be treated? Can I help? Dr. Murphy, on the other hand, performed his evaluation at the request of R.W. Sidley, and that is primarily what Dr. Murphy does. He performs evaluations for companies. He performs evaluations for the Industrial Commission, the Bureau of Workers' Compensation. I submit to you that his approach is different. And in that case, Dr. Murphy identified inconsistencies. And Ms. Summers has done a very good job of highlighting those inconsistencies. And I'm not going to tell you up here that there aren't inconsistencies. There certainly are. Mr. Reese, when asked about criminal history to Dr. Yingling, he reported that he had a DUI 20 years ago. In fact, at the time he saw Dr. Murphy, he reported that the DUI was 20 years ago, when in fact it had been 12 years. He didn't report the fact that he also had 2 misdemeanor convictions. Does that change the ultimate outcome? Does it change the fact that Mr. Reese was involved in a very serious accident? Does it change the fact that he had to have surgery? Does it change the fact that he developed symptoms of a depressive disorder and an anxiety disorder because he forgot to report 2 misdemeanors from 2014? I submit to you that it doesn't change the ultimate conclusion, even though it did for Dr. Murphy. Dr. Murphy also talked about inconsistencies in regard to the testing that was done. I want to talk a bit about the testing. Dr. Yingling, when talking about the elevated scales that we heard so much about in both Dr. Murphy's testimony and Dr. Yingling's testimony, Dr. Murphy indicated that his interpretation was Mr. Reese had a tendency to over-report some things and under-report other things. Dr. Yingling identified a similar issue when he interpreted the test results. Yet Dr. Yingling looked at the big picture. He looked at the injury that Mr. Reese had. He looked at the fact that he's had ongoing problems for the past 6 years. He looked at the fact that he had to have surgery for his issues. He looked at the fact that he reported all of these symptoms that are consistent with a depressive disorder and a panic disorder. He looked at the test results, and ultimately he included that despite the elevated scales, and this is a direct quote from Dr. Yingling, there's still the indication of clinically significant elevations of anxiety and depression scales, meaning that he's still endorsing symptoms of depression and anxiety that were clinically significant. So in looking at the big picture, Dr. Yingling reached the conclusion that Mr. Reese does meet the criteria for these two conditions, and that these two conditions were a result of the injury he sustained in January of 2019. The other thing that Dr. Murphy focused on quite a bit was the prescription medication that Mr. Reese was taking. And I think that this is really flawed for a number of reasons. First of all, the records point out that Mr. Reese was not taking the same medications consistently from the time of the injury until the time of the evaluations in 2021. In fact, just right around the time, maybe within 3 weeks or so of the time frame that Dr. Yingling evaluated Mr. Reese went and saw his main physician, Dr. Hockman. And you'll have Dr. Hockman's records, they're Exhibit 10. Dr. Hockman's office note of August 1st, 2019, he says he has taken Neurontin, but he's only taking it as needed. He's trying to minimize medications. He's not really taking them. So here we are within 3 weeks of the evaluation of Dr. Yingling and just a couple of months before the evaluation of Dr. Murphy. Dr. Murphy says that this combination of medications, trazodone, and he even mentions the blood pressure medications that Mr. Reese had been taking, that those could cause symptoms of a depressive disorder. But Dr. Yingling says, well, yes, there are certain medications that if taken consistently and regularly, there are side effects that would include things like cognitive issues or sleep disruption or a depressed mood. That to have that, you'd have to take those medications on a consistent basis. And he wasn't. The doctors were trying him on different medications at different times, and there was times when he really wasn't taking any medications at all, right around the time that he was being evaluated by Dr. Murphy. Yet Dr. Murphy wants to blame the symptoms that Mr. Reese described on the medications. And with regard to the panic disorder, I think that's really a problem because Dr. Yingling was very clear that those medications, while they could cause symptoms of a depressive disorder if taken consistently, they would not cause anxiety or panic. And Mr. Reese also experienced those symptoms. He talked about, and it's also in the records, he talked about trembling, heart racing, nausea. He talked about this feeling, this burst of energy, and having to go and walk around and try and find an outlet for it. All of those symptoms are consistent with a panic disorder. And Dr. Yingling says none of those medications, even if he was taking them consistently, would be consistent with a panic disorder. Dr. Murphy also points to the fact that Mr. Reese had a prior psychological problem. We know that in 2017, specifically July 14th of 2017, Mr. Reese went to his doctor, Dr. Manahar. Dr. Manahar's records are also contained in the book of exhibits. Let me go back with you to the jury room. Dr. Manahar's records are contained within Exhibit 3. And you're going to see that with regard to the psychological problems that Mr. Reese experienced previously, he went to the doctor one time for those problems, July 14th of 2017. He told his doctor, it doesn't work. And there's no indication in the records that Mr. Reese ever called him back after that. Why? Because as Mr. Reese said, I quit the job. I got away from the boss. I got away from the problem. I got away from the problem, and I went and got a job in Antarctica. He went to Antarctica for 6 months. No problems. No psychological problems, no physical problems. And when he came back, he got the job at Sidley. Despite the fact that Sidley knew he had a DUI in 2012, despite the fact that Sidley knew that he had 2 misdemeanor convictions in 2014, they had no problem hiring him. And he had no problem doing the job until January 24th of 2019. So are there inconsistencies? There are inconsistencies. Mr. Reese, when Dr. Yingling asked him about prior psychological, he only said that he saw a doctor for problems with his boss. He didn't tell Dr. Yingling that he had tried Paxil. Is that inconsistency significant enough to eliminate all the other things that we see and that he's reported and everything else that's contained in the records? I submit to you that it's not. The judge just read to you about the burden of proof, and we have the burden of proof. That's true. But understand that the burden of proof in a civil case is a preponderance of the evidence. Is it more likely than not that Mr. Reese has a depressive disorder and has a panic disorder? And is it more likely than not that those things were caused by the very serious injury, to use Ms. Summers' words, the very serious physical injury that he sustained, the injury that caused him to have surgery, the injury that's caused him to have ongoing memory issues, sleep issues, anxiety, depression? We believe that not only have we met our burden by a preponderance of evidence, we've met it by an overwhelming degree. But we're only required to just tip the scales in our favor. I would ask that when you go back to deliberate, you return a verdict indicating that Mr. Reese is entitled to participate in the workers' compensation system for the depressive disorder and for the panic disorder. And as I indicated during our voir dire, this is not a case where we are asking you to award money. Money damages are not awarded. Money is not a consideration in workers' compensation cases. It is a question of, can he participate for these conditions or can he not? That is the only question for you to deliberate. Thank you.
Thank you. Ms. Summers?
Thank you, Your Honor. Thank you, ladies and gentlemen of the jury. First of all, thank you for your time. Thank you for your patience. Thank you for sitting through 3 hours of testimony from 2 expert witnesses yesterday. I know that wasn't the easiest thing to sit through. So as I told you at the beginning, there are certain things that are not at issue. And I hate to reiterate it, but I'm going to because I think it's important. So we are not disputing that Mr. Reese sustained these physical injuries on January 24 of 2021. They include the concussion with loss of consciousness, post-concussive syndrome, and I'm going to talk about that a little bit more later. He had an injury to the left shoulder, and he had an injury to the neck. And as we've already stated, and as the judge indicated, we agree that Mr. Reese is allowed to participate in the Workers' Compensation Fund for those physical injuries. In fact, he is participating in the Workers' Compensation Fund for those physical injuries. That's not an issue. What is an issue is whether or not plaintiff suffers from these 2 psychological conditions that he's requesting be allowed in his claim. The, I'll call it depressive disorder, just to shorten it, and the panic disorder. I have this 2021 up here because I think during the course of this trial, we've maybe lost sight of the fact that we have to look at all this evidence and testimony through the lens of 2021, correct? The only expert who testified in this case, Dr. Yingling, on behalf of the plaintiff, who opined that he suffers from these 2 psychological conditions and that they arose from his physical injuries that he sustained in January of 2019, examined the claimant in 2021. He never saw Mr. Reese again after 2021, so he knows nothing about how Mr. Reese is today. Dr. Yingling didn't have a chance to see Mr. Reese on the witness stand today. And so, again, we have to think and consider all this evidence in terms of what was going on back in 2021, just 2 years after the injury at work, and not what's going on today in 2025 now. If you do not find, and I just wanted to tell you that at the outset, so when we go through this evidence, again, you're thinking about 2021 and not 2025. If you do not find, by the greater weight of the evidence, that plaintiff suffers from these psychological conditions, you have to return a verdict for R.W. Sidley. The first prong of this whole case is whether or not he actually suffers from these two conditions. If you find he doesn't, your job is finished. If you find that he does suffer from those two psychological conditions, and remember, when I say he suffers from, that he suffered from these in 2021, that's the date of the evaluation by Dr. Yingling, that's when he opined that Mr. Reese suffers from these conditions. If you agree with Dr. Yingling that in 2021 he had these two conditions, then you have to find that those conditions specifically arose from Mr. Reese's physical injuries that he sustained in January of 2021. In other words, Mr. Reese is not alleging that those conditions, those two psychological conditions, were worsened in any way by his injuries in 2019. He's saying the injuries in 2019 caused him to suffer those two psychological conditions. So if you find that plaintiff's psychological conditions actually pre-existed his work injury in January of 2019, then he is not entitled to participate in the workers' compensation fund. And I don't think I can stress this enough because there is a lot of confusion here. We have records that indicate he was treated for depression, anxiety, and panic disorders as early as 2017. But he's not alleging that or acknowledging that he had those conditions and that the work-related injuries worsened those conditions. He's saying the work-related conditions actually caused those two psychological conditions. You have to consider the evidence that you've heard, and as part of that, you have to determine what's reliable, what's credible. So let's talk about some of the evidence that you've heard. You heard from plaintiff, and I would submit that perhaps through no fault of his own, plaintiff's testimony was inconsistent and therefore not reliable. And let me just give you a couple of examples. I think you heard the plaintiff yesterday testify that back in the 2021 period, a year or so after this injury at work, he was a mess. And I think he said he had contemplated suicide on a couple of occasions. Well, think about what Dr. Yingling, his own expert, told you. Dr. Yingling said he specifically asked plaintiff about any suicidal thoughts, and this is in July of 2021. This is when Dr. Yingling's evaluation took place. And plaintiff told him, I thought about it once, but that was a while ago. That is exactly what he told Dr. Yingling at the time. We don't even know what he meant by a while ago. We don't know if he meant back in 2017 and 2018 was when he was first experiencing depression, panic disorder, and anxiety disorder, or did he mean after the accident at R.W. Sidley? It's not clear. He simply told Dr. Yingling, I thought about it once, it was a while ago. And Dr. Yingling, in his testimony yesterday, acknowledged that in his report, he says there is no evidence, again, July 2021, that plaintiff was suicidal in any fashion. Plaintiff also, back in 2021, okay, well, let me back up. You remember we talked with plaintiff about an accident he had in about 2000 or 2002. He had an accident on a bike which resulted in him fracturing vertebrae in his neck. He was actually life-flighted to a hospital and had to have surgery, fusion surgery for that. Well, he told medical providers that after that surgery in 2000 or 2002, he never had any problems with his neck again. Yet I showed you in my opening statement, and you will have these documents when you go back to deliberate, that show that in 2017, when claimant first started seeing Dr. Manahauer, who became his treating physician, he complained of chronic neck problems and in fact was taking medication for chronic neck problems. Yesterday on the stand, when I asked plaintiff about those records, he seemed to indicate he really couldn't recall at this point in time. But in fact, the history that he is providing to the doctors back in 2021 is not consistent with what we now know through medical records and through other documentation. For examples, but I think you get the idea. I think the biggest problem here is that when he was evaluated by Dr. Yingling and Dr. Murphy for purposes of this case, he failed to tell Dr. Yingling about his past psychiatric history at all. Dr. Murphy had some indication of it because he knew plaintiff had taken Paxil before he evaluated the plaintiff, and Dr. Murphy and Dr. Yingling both know that Paxil is prescribed to treat depression and anxiety or panic disorders. And I think that is the biggest problem with plaintiff's testimony and the history that he has provided to the two experts who testified in this case. So, let me say something about Dr. Yingling and Dr. Murphy, because counsel seemed to imply that Dr. Murphy wasn't as qualified somehow as Dr. Yingling. I strongly disagree with that. You're going to have the resumes of both doctors when you go back to deliberate. You can compare those resumes and make your own judgment. But you heard both of them testify. Dr. Yingling has been a practicing psychologist for 12 years. Nothing against a younger guy. Dr. Murphy has been a practicing psychologist since 1987. And you heard him say in the last 5 years he's cut back a little bit and he is doing primarily evaluations now. But that was not true for the other 30-some years of his career. He was a practicing psychologist. He's authored books on the subject. He's authored papers on psychology. He has worked with law enforcement in Ohio. He has worked with the Ohio Industrial Commission, the Ohio Bureau of Workers' Compensation. I would submit he actually has much more experience than Dr. Yingling in that regard. We know that Dr. Yingling had an incomplete history. He didn't know about plaintiff's prior social and legal stressors that might impact plaintiff's mental health status. As I said, he had no history regarding plaintiff's treatment with Dr. Manahauer in 2017 and the 2018 period for the panic disorders he was having and the depression and the anxiety. Dr. Yingling acknowledged that the claimant, when he evaluated Mr. Reese was taking 4 different medications. There's no dispute about that. Do we know the exact dosage? Do we know how much he was taking? No, I don't think anybody does at this point in time. Because again, plaintiff, I would submit, has not been totally forthcoming about that either. But the fact of the matter was, Dr. Yingling acknowledged that at the time of his examination, he asked Mr. Reese, and Mr. Reese told him about 4 different medications he was taking at the time of that evaluation. And Dr. Yingling conceded that all 4 of those medications can have effects that mimic depression and that can mimic panic disorders. Dr. Murphy, I think he had a slightly better history. He knew about the use of Paxil before his evaluation, or before the injury at work, I should say. He also had a little more information about Mr. Reese's social and legal history. He knew about some of the legal problems that Mr. Reese had had. And he reported that in his report. He also, clearly knew about the different medications that Mr. Reese had been taking or that doctors had been prescribing in an effort to try to find medications that worked for him. And Dr. Murphy was very concerned that these medications that Mr. Reese was taking were causing these symptoms that he was reporting of depression, of panic disorders. And so we do actually have consistency here to some extent between Dr. Yingling and Dr. Murphy in terms of what side effects the medications Mr. Reese was taking could potentially have. You heard about the testing that both doctors performed. There is some issue about the testing in that Dr. Yingling never provided his test scores. Remember, he told you he performed a written test, or he had Mr. Reese perform a written test, and he scored that test, but he never told us what the scores was. He saw the scores, but he never provided them to Mr. Reese's counsel, to me, to Dr. Murphy never got a chance to see those scores, and Dr. Murphy points that out in his testimony. I would submit that those scores are important because Dr. Yingling also testifies that those scores were then adjusted in some manner. And it's unclear how they were adjusted, and we can't determine how they were adjusted because we don't have the scores. And as Dr. Murphy said, without the scores, you can't compare those scores, those numbers, to the symptoms that Mr. Reese was reporting. Dr. Murphy did, again, as I said, he reported his scores in his report. And here's another thing that they both have in common. Those scores indicated there was some evidence of exaggeration. I talked about this, I think, in my opening statement. Exaggeration of symptoms. And the scores that Dr. Murphy and Dr. Yingling compiled suggested that perhaps Mr. Reese was exaggerating some of his symptoms. In addition, Dr. Murphy's tests revealed that maybe he was underreporting some of the other stressors in his life that could be contributing to his mental status. I would also point out that, you saw plaintiff on the stand yesterday, and clearly he's got a lot going on with some cognitive issues. I mean, the claim is allowed for concussion and post-concussive syndrome. We don't deny that. He does have some cognitive issues. But interestingly enough, back in 2021, when he was evaluated by Dr. Yingling, and Dr. Yingling is the expert who testified in this case, Dr. Yingling, remember, told you he drove himself to the exam. He was alert. He was oriented. He answered questions. He seemed rational. And think about this. The two tests that were administered to plaintiff, they were different tests. They're both equally good, no doubt about that. I think it's just a difference I think it's a difference in the two psychologists in terms of what tests they perform. Dr. Murphy's test was about 30 minutes long. I don't know if you caught that. And he said it took the plaintiff about 30 minutes to finish the exam. And that was completely normal. Dr. Yingling administered this NMI test, and if you caught what Dr. Murphy said about that test takes 2 to 3 hours. So Mr. Reese, back in 2021, was able to sit for 2 or 3 hours to take this written test that Dr. Yingling administered, and there's no evidence he had any problem completing the test. There's no evidence he had any struggles with comprehending the test. Unlike what you saw yesterday in the courtroom, now 4 years later, perhaps things have changed. But again, we have to look at all of this through the lens of 2021, when the plaintiff's expert evaluated the plaintiff and came to his conclusions. Finally, you're going to have some exhibits, as I've already said, that you're going to be able to take back with you and look through if you choose. Those exhibits, first of all, I talked about this in opening. I'm not going to go through it again. They document the legal history that Mr. Reese started experiencing, at least in the 2013-2014 period, with the DUI, with the charge of aggravated menacing that was reduced to disorderly conduct, another disorderly conduct charge because he got into an altercation with the police officer. Those are all documented. But also, you're going to have the exhibits that document plaintiff's prior mental health issues, and those are the records of Dr. Manahauer. And I've already went over some of these. I'm not going to belabor it. But again, this is 2017, and Mr. Reese it looks like he's seeing Dr. Manahauer for the first time. A chief complaint, severe anxiety attacks. He was given some kind of medication, but he was not taking it, and I think that's actually Paxil, due to side effects. So here we have this July 17, 2017 record, but you can see the plaintiff had had problems before he even saw Dr. Manahauer. With the passage of time, we don't have those records. So we don't know what all was involved, what caused him to go to the urgent care in the first place with these severe anxiety attacks he was having to get medication. We don't know, because we don't have that information, what was behind that. But he shows up to see Dr. Manahauer in July of 2017, and he's having all these complaints about severe anxiety attacks, depression, anxiety disorder. Dr. Manahauer reflects, some numbers on the Zung depression scale. I mean, clearly this was pretty serious. And here you see the history of the neck pain. Now remember, this is before his injury at R.W. Sidley in 2019. This is 2 years before, and he's talking about having a history of neck pain, presumably from the prior neck injury he had in 2000 or 2002. Again, this is just sort of more of the same. Oops, I'm sorry. Oh, that's just to show you the date, because it's kind of weird. The date wasn't on the first page of this document. It's here where the vital statistics are recorded, July 14 of 2017. And here, the diagnosis or problems: depression, neck pain, orders for anxiety disorder. He actually, Dr. Manahauer actually prescribed medication for Mr. Reese at this point in time for his mental disorders. And patient discussion summary: depression, anxiety order, start on Celexa. Patient has chronic neck pain, and he was taking medication for that, again, 2 years before the accident at R.W. Sidley. And then, okay, let's see, I think I'm going to go back one. Then we have a record from August 27 of 2018, and this is just about 5 months before the accident at R.W. Sidley. And Mr. Reese is still treating with Dr. Manahauer, who is his sort of treating physician at this point in time. I think I lost where I was trying to go, sorry. Can I go backwards? Which one do I hit?
There's a back arrow.
Oh, okay, I got it. Yeah. So let me just go back for a second to Dr. Manahauer. Okay. Okay, so this is what I wanted to show you. This is actually a record from August of 2018, which I said is about 5 months before the accident or the injury at R.W. Sidley. And you can see that Dr. Manahauer still lists as active problems anxiety disorder, cervical radiculitis, which is an issue with the neck, and depression. And it's interesting because right here by this anxiety disorder, Dr. Manahauer indicates it was added by problem list migration on 12/14/2013. Now that appears to suggest that Mr. Reese was actually having problems with anxiety disorder as early as 2013, as recorded in Dr. Manahauer's records now in August of 2018. And again, he is still showing an active problem of anxiety disorder. So I don't think it's fair to say that Mr. Reese had recovered from any mental health problems he was having by 2018, because right here we have it in his treating physician's records that is still considered by his treating doctor to be an active problem. And then I wanted to go over one more document that I think is kind of important, because counsel for plaintiff has talked about this document a lot, and she brought it to the attention of both experts in this case. And this is the evaluation of Dr. Kip Smith, who is a PhD, who apparently does rehabilitation psychology. So Dr. Kipp is a psychologist. Dr. Kipp was not called to testify in this case, but we do have this record from 8/5/2019 from Dr. Kipp. And here is where, for the first time, we start seeing some other history that Mr. Reese does not tell Dr. Yingling or Dr. Murphy about when he is evaluated by them in 2021. But he thought it was significant enough to tell Dr. Smith. He tells Dr. Smith that he is estranged from his birth family and has been more than 25 years. He is reluctant to elaborate, but refers to an inheritance that he was cheated out of. He seems reluctant to discuss further. Now, I point that out because remember when Dr. Murphy said his testing indicated the plaintiff tends to underreport certain things? There is another example from another psychologist who saw Mr. Reese back in 2019 with this same reluctance to discuss his personal problems. And remember, Dr. Murphy said part of the problem of trying to diagnose somebody and find out what's causing a problem is if they're not forthcoming. It makes it very difficult then to come to a correct diagnosis and a solution, perhaps, a way to treat the diagnosis. Look here, past psychiatric history. Now, this is just 2 years after he saw Dr. Manahauer in 2017 for anxiety disorder, panic attacks, and depression, and was treated with medication. And before that, he had been treated with Paxil. He tells Dr. Smith that he has no psychiatric history. So again, another example of plaintiff either underreporting or just refusing to report certain things to the doctors who are simply trying to evaluate him and try to figure out what's wrong with him. Substance abuse history. Alcohol use was described as minimal, but it appears he may be minimizing his use. So Dr. Smith didn't even believe him when Mr. Reese told Dr. Smith that he was not using a lot of alcohol. I don't know why, because there's no other context, but again, this psychologist did not think he was being truthful about his alcohol usage, and that's in 2019. And I think this is the most important thing. Okay, well, first of all, look at the mental status exam in 2019 of this psychologist, who I think is employed by the Bureau of Workers' Compensation. Mr. Reese was well-groomed, he was cooperative, he was oriented to place, a person, place, date, situation. His speech was clear and normal. His thought process was logical and organized. Judgment fair, attention span sustained. He was anxious and a little overwhelmed. But that is pretty consistent with how Mr. Reese presented himself to Drs. Yingling and Murphy when they did their evaluations. It's a lot different from what we saw in the courtroom yesterday. But again, you've got to transport yourself back to 2021, because that is when the expert for the plaintiff in this case evaluated Mr. Reese and determined that he suffered from these two conditions and that they were related to his work injury. Now, Dr. Smith goes on to say he presents with multiple symptoms consistent with post-concussive syndrome. Dr. Smith does not say these symptoms are related to depression or that they're related to panic disorders. They're related to the post-concussive syndrome, which is allowed in Mr. Reese's case and for which he is allowed to participate in the Workers' Compensation Fund. And Dr. Smith goes on to enumerate those symptoms: impaired sleep, headaches, dizziness, visual disturbance, irritability, low frustration, anger, anxiety, cognitive issues, impaired memory. So he's having all those problems back in 2019, and this psychologist says it's related or consistent with his post-concussive syndrome. That's one of the physical conditions allowed in the claim for which Mr. Reese is allowed to participate. The doctor here, the psychologist here, does not relate those symptoms to panic disorder or depression. Dr. Smith goes on to say it's recommended he receive individual psychotherapy, but I would submit that counsel tried to mislead you in her closing argument by suggesting that psychotherapy was for depression or panic disorder. That is not what this document says. This psychologist is recommending psychotherapy for his post-concussive syndrome and not for any depression or panic disorders, because there's no such diagnosis in this evaluation. I would submit, ladies and gentlemen, that the greater weight of the evidence, and remember, it's plaintiff's burden of proof, plaintiff has to prove that he suffered these two psychological conditions back in 2021 at the time of Dr. Yingling's evaluation, and that those psychological conditions specifically arose from his physical conditions that are allowed in his workers' compensation claim. I would submit that the greater weight of the evidence does not support either of those propositions, and if you agree, then you have to find that Mr. Reese is not entitled to participate in the workers' compensation fund for those two psychological conditions. Thank you.
Thank you. Ms. Kraus?
Thank you, Your Honor. I'm just going to hit a few points that I want to make. Ms. Summers talked quite a bit about the evaluation having taken place in 2021, injury having been in 2019, and that's true. And all I can tell you is that we have no control over when this case actually gets to trial. Sometimes the wheels of justice move slow. Remember in this particular case that even though he had an injury, a very serious injury to his neck in 2019, he didn't have surgery until 2.5 years later in May of 2021, despite the fact that, as Ms. Summers said, Sibley wasn't contesting the underlying nature of the claim. So sometimes, unfortunately, things take time to get to the point of being addressed. Notwithstanding the fact that Mr. Reese was evaluated by the two doctors in 2021, the reality is the symptoms he described then are still the same symptoms he's describing now, and they're the same symptoms that you'll see in Dr. Vargo's records in 2019, and 2020, and 2021. And they're the same things that Dr. Yingling and Dr. Murphy testified to. And the reason for that is because he hasn't had any treatment for these conditions. Dr. Smith, back in August 5th of 2019, said he should be treated every week or every other week. And he hasn't had any of that treatment. So, of course, the symptoms that he's exhibiting of the depressive disorder and the panic disorder remain present. Ms. Summers made a point about the prior psychological history that Mr. Reese has experienced. And I want you to really pay particular attention to the records of Dr. Manahar. And you'll have them with you in Exhibit 3. Ms. Summers interpreted, I think, this reference to something with regard to 2013, suggesting to her that the problem began this added by problem list migration, 1312-14. She says, well, that means the symptoms all actually started back in 2013. Well, first of all, we don't know that, okay? There's no evidence of that. She's assuming that. And second of all, that doesn't make any sense. Mr. Reese didn't see Dr. Manahar in 2013. The first time Mr. Reese saw Dr. Manahar, you'll see in the record, was July 14th of 2017. And on July 14th of 2017, he says that he's here for the first time, he's having anxiety attacks, and he went to the emergency room, and they gave him Paxil. And he's not taking the medicine because of the side effects. And at this point, Dr. Manahar, who's seeing him for the first time, says he has a depressive disorder and he has symptoms of anxiety. And he gives him Celexa. And then he says, call me if not better. And then there's nothing. The next time that Mr. Reese is at Dr. Manahar's office is not until 2018, in February. So 6 months later. And at that time, there's no indication. It says he's not taking Celexa. He's here for a regular follow-up for high blood pressure and allergic rhinitis. He denies any chest pain, shortness of breath, palpitations, no headache, no dizziness, nothing. So these psychological problems that there's been such discussion about are one visit to his family doctor on July 14th of 2017. That is it. Until he has this serious injury at work. Ms. Summers also talked about the fact that because of these prior psychological issues, Dr. Yingling has said that these conditions were, the depressive disorder and the panic disorder, were caused by the accident. He isn't suggesting that they were in some way aggravated, and she's suggesting that he didn't really know about the prior psychological history. But yet, when asked, this is during Dr. Yingling's deposition, this is a quote from Dr. Yingling. He says, "So, when I asked specifically about psychotherapy or mental health counseling, he referenced that he had seen a mental health provider for a conflict with a boss." He did tell him about it. He just didn't tell him that one time he took Paxil. That's the only inconsistency. And when Dr. Yingling made his diagnosis, he took that prior history into consideration. And how do we know that? Because when you go back to the jury room to deliberate and you look at the verdict forms, the title for the full title for the depressive disorder that Dr. Yingling diagnosed is Other Specified Depressive Disorder, Recurrent Brief Depression. So he knew about what had happened in 2017, and he took it into consideration. But as Mr. Reese testified, it was one time with one boss, I quit, and that was the end of it. Again, I would ask you to also pay attention, in addition to those records from Dr. Manahar, which are Exhibit 3, we've pulled out the records of Dr. Vargo. There's records from 19, 20, and 21. And you'll see in those records the same sort of psychological symptoms that Mr. Reese described in 21 to Dr. Yingling and to Dr. Murphy. And that if you, again, look at the big picture, despite some inconsistencies about not telling one doctor about Paxil and not telling a doctor about 2 misdemeanors, if you look at the big picture, we have a gentleman who sustained a serious injury and developed symptoms of a depressive disorder and a panic disorder. And we would ask that when you go back, you return a verdict in Mr. Reese's favor. Thank you.
Thank you, Ms. Kraus. I will pick up again if you want to follow along on page 5 of the instructions. The court cannot embody all the law in any single part of these instructions. In considering one portion, you must consider it in light of and in harmony with all the instructions. The court has instructed you on all the law necessary for your deliberations. Whether or not certain instructions are applicable may depend upon the conclusions you reach on the facts by a greater weight of the evidence. If you have an impression that the court has indicated how any disputed fact should be decided, you must put aside such an impression because that decision must be made by you based solely upon the facts presented to you in this courtroom. Circumstances in the case may arouse sympathy. Sympathy is a common human emotion. The law does not expect you to be free of such normal reactions. However, the law and your oath as jurors require you to disregard sympathy and not to permit it to influence your verdict. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to weigh the evidence, to decide the disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. The court has given you the instructions on the law applicable to this case. I will now instruct you on how to conduct your deliberations and prepare your verdict. When you go to the jury room, your first function will be to select one of your number to serve as a foreperson. The person you select to preside over your deliberations does not have any greater power, nor does that person's vote have any more importance than any other jurors. He or she serves the purpose of helping to conduct your deliberations in an orderly manner and to give each of you express your opinion. One additional duty of the foreperson is to see to it that the verdict forms and any exhibits are returned to the court after you have reached a verdict. If you took notes during the trial, you may take your notes to the jury room. The fact that the notes taken by a juror support his or her recollection in no way makes his or her memory more reliable than that of the jurors who did not take notes. All notes will be returned to the bailiff for destruction when the jury is discharged. The court will place in your possession the exhibits, a copy of the jury instructions, and the verdict forms. There are two verdict forms, one for other specified depressive order, recurrent brief depression, and one for panic disorder. And each of those reads in the first paragraph, "We, the jury, having been duly impaneled, sworn, and affirmed, hereby find that Martin A. Reese either is or is not entitled to participate in the Workers' Compensation Fund for the condition of," in the first verdict form, other specified depressive disorder, recurrent depression. On the second verdict form, panic disorder. And you are to circle either is or is not, depending on your findings. The foreperson will retain possession of these records, including the verdict, and return them to the courtroom. The foreperson will see that your discussions are orderly and that each juror has the opportunity to discuss the case, to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. Until your verdict is announced in open court, you are not to disclose to anyone the status of your deliberations or the nature of your verdict. Deliberations may take place only when all jurors are in the jury deliberation room together and with no one else present. Should any juror leave the room, all deliberations must cease until all jurors are together. During your deliberations, no juror is permitted to disclose to anyone the status of your deliberations or the nature of your verdict. This order must strictly be obeyed. During recesses, you may not discuss the case with anyone, even other jurors. Your initial conduct upon entering the jury room is a matter of importance. It is not wise to immediately express a determination or to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to give up your position, even if you later decide that you are wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement, if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender your considered opinion concerning the weight of the evidence in order to be congenial or to reach a verdict solely because of the opinion of other jurors. In order to conclude this case, it is necessary that at least 6 members of the jury agree upon the verdict. The members of the jury agreeing upon the verdict must sign their names in ink to the form of verdict which they have agreed. And you will see a line for each of the 8 jurors. Each has your name printed below, and you need to sign above where your name is printed. The foreperson need not be among the jurors who agreed in order to reach a verdict. If you have any question or request during your deliberations, your foreperson should write that question or request on a piece of paper and notify the bailiff so that the question or request can be delivered to me. The court cautions you, however, with regard to any message or questions you might send, that you should not reveal your numerical division at the time or the status of your deliberations. It should be reduced to writing so there will be no misunderstanding as to what you request. It should then be delivered to the bailiff, who will submit it to the court. When you have reached and signed a verdict, you will sign the verdict in ink and advise the bailiff by using the buzzer in the jury room. You will then be returned to the courtroom. As mentioned earlier, you have heard all the evidence. It is common practice when jurors commence deliberation to request transcripts of various witnesses. There are no transcripts. Mr. Weil, you were selected to serve in the event of any misfortune to any member of the panel. At this point, you will not accompany the jury to the jury room or participate in deliberations unless directed by the court. Please remain in the courthouse until the court directs you that it will not be necessary for you to serve any further. You are not to discuss this case or tell anyone how you would have voted until after the jury has returned a verdict. After you are discharged, you may discuss your verdict and your deliberations with others, but you are not required to do so. You must decide for yourself whether or not to discuss such matters. Is there anything else from counsel?
Nothing, Your Honor.
All right, you may now start your deliberations.
All right, the jury.
Oh, wow. Okay. Can we beat that?
All right, anything else for the record?
No, Your Honor.
Okay.
I have nothing, Your Honor. Sorry, I'm too busy tripping.
I wondered whether that was.
Not on drugs. That's how I'm tripping. I'm from that generation, but that's not what I was doing, Your Honor.
All right, where are the exhibits? Which book is it? That one? Perfect.
Thank you. Yes. Yes, but not, you don't have to sit right in here, you can walk around.
Thank you.
You know.
Thanks so much for your help.
These are for you guys.
Oh, thank you.
Ladies and gentlemen, have you reached a verdict?
Yes, we have.
All right, would you hand it to Mr. Gonzalez, please? All right, Martin A. Reese versus R.W. Sidley Incorporated, 24 CV 265, verdict form as to other specified depressive disorder, recurrent brief depression. We, the jury, having been duly impaneled, sworn, and affirmed, hereby find that Martin A. Reese is not entitled to participate in the Workers' Compensation Fund for the condition of other specified depressive disorder, recurrent brief depression, and we do so render our verdict upon the concurrence of 8 members of the jury, that being 3/4 or more. Each of us, said jurors concurring in said verdict, sign our name here to this 14th day of January 2025, signed by all 8 jurors. Verdict form regarding panic disorder. We, the jury, having been duly impaneled and sworn and affirmed, hereby find that Martin A. Reese is not entitled to participate in the Workers' Compensation Fund for the condition of panic disorder, and we do so render our verdict signed by all 8 jurors. Does either side wish to have the jury polled?
No, Your Honor.
All right, thank you very much, ladies and gentlemen. If you can go back to the jury room, I'll be back in a few minutes to speak with you. Thank you very much.
All right, the jury.